The license grant section of a EULA is where the most important business terms can be found. These are the key terms and conditions that are specific to your requirements, your financial investment, and your particular acquisition. The 12 elements of a license grant will be discussed in this tutorial. The license grant section includes key items such as define the parties to the agreement. The party entering the contract and placing the order should be clearly identified. For example, define the major command, executive agent, activity, or budget support office. It is a best practice to have the publisher as a direct party to the EULA even when a reseller is involved. Detailed requirements and objectives for the software should be clearly defined. Attach documentation to help explain why this software was selected and the features and benefits you are expecting and were promised by the sales team. The EULA should fully cover the names of the products you are licensing, the functions to be performed by the software, and information about the operating systems or hardware on which the software will perform best. The duration of your right to use the software should be clearly defined. Typically, software is licensed in perpetuity or for a specified term of months or years. A perpetual license grants the customer use of the software in perpetuity. A term or periodic license grants the customer use of the software for a specified period of time, such as 1 year, renewable annually. Software maintenance may or may not be included in the term license price, so be sure to understand the specific terms and conditions of an offered term license. All required and anticipated uses of the software should be permitted by the license. It is usually best to have a broad sweeping clause that allows for the software to be used for any lawful business purpose. If there are legitimate restrictions, ensure that language is reasonable and accurate. For example, some software may only be used for demonstration purposes, development and test purposes, or backup and recovery needs. Beware of restrictions such as, the software may not be used for internet transactions or access. The authorized users need to be clearly and fully identified. Authorized users may include military, reserves, civilians, contractors supporting the government, and coalition forces. Be sure to not limit the description of the intended users. The EULA should not restrict the government's right to transfer the license to any other organization within the Department of Defense, known as affiliates of the original licensee. Define the geographic area in which the software may be used. The default position for government use rights should cover worldwide usage. Only in extreme circumstances should the geographic scope be limited to anything other than worldwide. The EULA should clearly define the written and spoken languages that will be understood by the government user community. This includes the visual screens in the software, file names, language spoken by the support desk personnel, training classes, and all documentation. Multiple languages may be needed to support coalition forces and authorized foreign nationals working with the government. Clearly define the quantity of licenses being acquired and how licenses will be counted in the future when an audit is performed. Identify the number and type of licenses that can be copied without additional cost. This could include use at home by government employees, backup copies, or licenses for disaster recovery purposes. The best practice for government buyers is to perform a self-audit of the quantities and usage of software licenses and not allow the publisher or reseller to perform its own audits on government systems. Be sure to include contractual provisions that allow the government to temporarily expand the number of licenses it needs in times of conflict, emergencies, or other temporary expeditionary deployments. Ensure the government owns all rights to its data in any situation. When enhancements, customizations, or other special software code is required for the commercial software to meet the government's requirements, it should be very clear who owns the intellectual property rights to that special software code. This new product is known as derivative work because they were derived from the original software product. The default position should grant exclusive ownership rights to the government. In exceptional circumstances, the derivative work can be jointly owned by the government and the publisher. Thank you for viewing this tutorial. Please visit the DoD ESI website for more information and other videos in this series.